To form a partnership, parties aren't legally required to execute a written agreement. However, when parties form business relationships without formally stating their intentions in writing, courts may define those business relationships using their own factors. In MAS Associates LLC versus Korotki, the Maryland Court of Special Appeals analyzed the intentions of three parties who operated a business without signing a written agreement. Harry Korotki, owner of Savings First Mortgage, contacted Greentree Mortgage, owned by Joel Wax, and MAS Associates, owned by Saralee Greenberg, to negotiate merging the three lending companies. The companies had independent counsel draft a merger agreement stating the parties' intention to become members of MAS and to share profits and decision-making equally. However, before signing the agreement and seeking regulatory approval for their merger, the companies merged their employees and assets. Korotki, Wax, and Greenberg each contributed $150,000 to fund their new business venture. When MAS became profitable, the three owners agreed they would each receive a monthly salary, and on 2 occasions, they agreed to profit distributions. After less than 2 years in business, Korotki notified Wax and Greenberg that he was leaving MAS for health reasons, on the advice of his physician. Korotki asserted that the parties' unsigned agreement entitled him to a disability-related buyout. When Wax and Greenberg refused, Korotki filed suit. The trial court ruled that Korotki, Wax, and Greenberg never formed a contract because they never signed the written agreement and never demonstrated their intent to be bound by its terms. However, the court found that the parties had formed a partnership. The court awarded Korotki the value of his interest in the partnership, which it determined was $793,000. Wax and Greenberg appealed to the Maryland Court of Special Appeals.